of TCC Judgment 113, 宪判 6 of 2024, case on the constitutionality of height requirements for firefighter entrance exam. Head notes. Article 8, subparagraph 1 of the Civil Service Examination Regulation for General Police Officers, which stipulated different height requirements of men and women for the firefighter entrance exam, did not pass the intermediate scrutiny review. It was unconstitutional for leading to unfair differential treatment relating to sex in its application, consequently violating equal protection under Article 7 of the Constitution. TCC referred to national health data and found that the provision has excluded a higher percentage of female citizens than male citizens without sufficient evidence to justify the conclusion. Article 7, paragraph 2 of the Civil Examination Regulation for General Police Officers, which stipulates that qualified firefighters trainee may be asked to undergo re-examination of their physicals by the Training Institute when necessary, was constitutional. The wording regarding when necessary stipulated therein conformed to the principle of legal clarity. The petitioner's final court decision was quashed with its matter remitted to the Supreme Administrative Court. Background note. Article 8, subparagraph 1 of the Civil Service Examination Regulation for General Police Officers, which also applies to the firefighter entrance exam, stipulates that examinees would fail their physical examination at the second stage of the exam if they couldn't meet the following height requirements: 165 centimeters for non-indigenous men, 160 centimeters for non-indigenous women, 158 centimeters for indigenous men, and 155 centimeters for indigenous women. Furthermore, under Article 7, paragraph 2 of the Civil Service Examination Regulation for General Police Officers, qualified trainees who pass the exam may be asked to re-examine their physicals by the Training Institute when necessary. Those who failed would be disqualified by the Civil Service Protection and Training Commission. The petitioner, Mr. Yuan Xuan Chen, passed both the writing exam, first stage, and the physical examination, second stage, for the firefighter entrance exam in 2018. However, she was later asked to undergo a re-examination of her physicals during training. The petitioner was measured at 158.9 centimeters upon re-examination, not meeting the height requirement for non-indigenous women. The petitioner was subsequently disqualified. After ensuing administrative appeal and judicial litigation, her case was finally dismissed by Supreme Administrative Court. The petitioner filed a constitutional complaint arguing that Provision 1, which implements height-based qualification for qualification of firefighters, would not pass strict scrutiny, and that it disproportionately barred more women from becoming firefighters, thus violating the equality principle. Provision 1 disproportionately excludes non-indigenous women shorter than 160 centimeters altogether without considering the various types of tasks in the firefighting agencies that shorter people may have advantage in performing. And the term "when necessary" in Provision 2 is hard for trainees to comprehend and foresee, thus lack legal clarity. The case was argued on January 16, 2024. Summary of the judgment holding. 1. Article 8, subparagraph 1 of the Civil Service Examination Regulation for General Police Officers herein after Provision 1 and the Police Exam Regulation stipulates examinees with one of the following results in his or her physical examination should be disqualified: height men shorter than 165 centimeters and women shorter than 160 centimeters. The application of this height requirement provision in firefighter entrance exam excludes a significantly higher percentage of female examinees than their male counterparts. Said differential treatment imposes a disadvantage to the female examinees' right of taking public examination and holding public office, which does not conform to the equal protection. Under Article 7 of the Constitution, Provision 1 should cease to be effective 1 year from the date of announcement of this judgment. Article 7, Paragraph 2 of the Police Exam Regulations stipulates that after enrollment, trainees may be required to re-examine their physicals in public hospital designated by the Ministry of Interior or Ocean Affairs Council when necessary. Trainees who fail their physicals should be disqualified by the Civil Service and the Training Commission with a letter. The term "when necessary" in the provision does not violate the principle of legal clarity. 3. Supreme Administrative Court Judgment 109-928 of 2021 herein after the disputed judgment is unconstitutional and shall be quashed. Its case shall be remitted to the Supreme Administrative Court. Reasoning: constitutional rights and the standard of review pertaining to this case. Equal protection under Article 7 of the Constitution does not prohibit all forms of differential treatment. The legislators and the relevant authorities may, based on the value system presented in Constitution and their legislative purpose, stipulate reasonable differential treatments considering the different nature of the regulated matters. Because the sex is a merely immutable characteristic that people are born into, law that impose differential treatment with sex-based qualification should be reviewed under intermediate scrutiny. Such laws should further important public interest and by means that are substantially related to that interest. Within the scope that it is applied to firefighter entrance exam, the height requirements of Provision 1 substantially exclude a majority of women from being qualified examinees. Provision 1 resulted in disadvantageous differential treatment relating to sex in its application. According to the statistics from 2017 to 2020 by the Health Promotion Administration, Ministry of Health and Welfare, the average height of the male citizen within the age group that is eligible to take a firefighter entrance exam is 172 centimeters. The average height for their female counterpart is 159.5 centimeters. Considering the difference in height between men and women in this country, Provision 1 provides differential minimum height requirements for examinees. The minimum height for male examinee is 165 centimeters, which is 7 centimeters shorter than average and excludes approximately 10% of the men in the age group placed on the percentile ranks. In contrast, the minimum height for female examinee is 160 centimeters, which is 0.5 centimeters higher than the average and excludes approximately 55% of the women in the age group based on the percentile rank. The application of the provision results in sex-related disparity that demonstrate a statistical significance. According to national human rights statistics over the years, such significance exists on a long-term and consistent basis. It is substantively determined that the Provision 1 has resulted in disadvantageous differential treatment to women's right of taking public examination of holding public offices. Provisions 1 further an important public interest consider the operational need and the safety of the firefighters, the diverse nature of disaster and the emergency response, and the safety of operating heavy machinery. The height and the physical fitness of the firefighter are essential to the success of a mission. Due to the consideration mentioned above, the Provision 1 stipulated high criteria as one of the requirements for the physical exam of the firefighter entrance exam. Provision 1 also set up a differential threshold for the height of male and female examinees based on the difference in average height between the two sexes. The objective of Provision 1 is of important public interest. Provision 1 means it is not substantially related to its purpose. According to statistics, male firefighting personnel constitute 88% of the firefighting force, whereas the female counterpart account only for 12%. The application of Provision 1 has consistently shaped the work environment and culture of the police and firefighting force to cater to and to be defined by male needs, which makes it hard for women to participate. Relevant authorities argue that the higher threshold for female examinees were decided based on the firefighting experience and tacit knowledge, as well as the consideration of equipment purchasing, occupational safety, and superiority in disaster response. However, based on their statements given during oral arguments, purchase of equipment can be adjusted. The agent at the item for National Fire Agency in this case admitted in a lower court that there was no scientific evidence to support the claim that a person shorter than 160 cm would incur unbearable hazard when operating their machinery. However, taking into account the diverse situation in firefighting and the disaster response, shorter firefighters have their relevant advantage, which is essential to complete disaster response team. In conclusion, the relevant authority failed to provide substantial evidence why women shorter than 160 cm would be unfit for firefighting, and the strict height requirements should be set for female examinees to exclude most women from taking this exam. Therefore, such disadvantageous differential treatment that the Provision 1 imposed on women is not substantially related to its purpose. Within this scope, that it applied to firefighting entrance exam, Provision 1 violated equal protection under Article 7 of the Constitution. Provision 1 should cease to be effective 1 year from the date of the announcement of this judgment. Relevant authority should note that the amended height requirement should not create too much sex-related disparity when disqualifying examinees. The restriction that Provision 2 imposes on people's right of taking public examination and of holding public office do not contradict the principle of legal clarity. Although a term, when necessary, in Provision 2 is an indefinite legal term, indefinite concept of law, its meaning and connotation are comprehensible under common sense. Furthermore, it is foreseeable for the person regulated under the Provision 2, that is, the examinee and trainees, that the re-examination of their physicals may be required when there are doubts regarding their physical fitness. Application of Provision 2 may be reviewed by a court applying general legal interpretation method. Provision 2 does not contradict the principle of legal clarity. The disputed judgment is unconstitutional. It shall be quashed and its matter remitted to Supreme Administrative Court. Article 16.4, Paragraph 1 of the Constitution Code Procedure 8 stipulates that in a judgment where a time period is set for impugned legal provision to lapse, the competent authority to which the underlying case of relevant final court decision is remanded to shall decide in accordance with the ratio decidendi of the judgment of a constitutional court by which the impugned legal provision is declared unconstitutional, notwithstanding the time period set forth for the lapse of the legal provision declared unconstitutional, unless the holding of the judgment otherwise decided. Provision 1, which disqualifies the petitioner upon re-examination of his physical, is declared unconstitutional by this judgment, although it is given a time period before its lapse. Its high requirement is unconstitutionally flawed ab initio. However, considering the time that the petitioner had invested, the uncertainty of amending the provision may severely affect her equal right of taking public examination and of holding public offices. To protect her constitutional right as well as to stay in line with the court's intention to encourage petitioner, the disputed judgment shall be quashed with its case remitted to Supreme Administrative Court. The Supreme Administrative Court shall decide following the ratio decidendi in this judgment, notwithstanding the time period set for the lapse of disputed provision.